Good afternoon and welcome to today's CLE webinar. My name is Peter Crofton. I am the chair of the construction law section of the State Bar, and today we are pleased and delighted to be doing a joint presentation with the IP section of the State Bar, and in particular with the subcommittee of that section for copyrights. I want to thank obviously both sections for working to put this event on today, and I'd also like to thank our panelists, who I'll introduce in just a second, and Rachel Geist, who's been instrumental from the IP side in helping us put this presentation on. Obviously, the State Bar is a big help. I'd like to thank Lane, who's helping us today with running our video. Lane asked me to tell you that you don't need to do anything further to get your CLE credit by registering. All that information's in the State Bar system, and they will automatically port the information over for purposes of issuing the credits. I've also been asked to tell you that the chat function has been disabled. And so if you have any questions during the event, and I hope you will, please put those in the Q&A, I don't know what they call it, portal or what have you, so we can pick those up and use those with our panel. Today, the discussion is going to be on issues that are common to the construction world and to the IP world, and in particular to the copyright side of that. Construction projects have become ubiquitous around town. You can look outside, see the cranes. You can also begin, if you look at some of the technology that's now being used in the construction area, perhaps understand that there are a number of issues that are coming up now that we haven't seen in the past, or perhaps they're newer variations of past issues. And it's an area that often is not well explored on the front end of construction projects and transactional issues, but it's good for both IP and copyright lawyers to understand what happens in the construction field and vice versa, because these issues are very real, and we're seeing a lot of them in the news right now. I'd like to start by introducing our panel today. First, we have Liza Atkins. Liza is the Assistant General Counsel with ARCO Design Build. That's a national design build contractor. Liza is a former engineer, where she spent her legal career focused on construction law, representing owners, general contractors, and subcontractors in both transactional, which are obviously all the contracts that go up front, and litigation matters, which is when the contracts aren't right, we all fight. Prior to working for ARCO, Liza was an associate at Kilpatrick Townsend and at DLA Piper. We also have Greg Jacobson with us. Greg's an attorney at King & Spalding in the Construction and Technology Transactions Group. Sounds like he spans the gap. His practice involves advising global clients on complex construction projects and cutting-edge technology issues through the drafting and negotiation of a wide variety of commercial agreements. And over $20 billion of construction agreements are under his belt. Greg has been honored as a Georgia Trend Legal Elite and a Super Lawyers Rising Star, and recently completed a secondment with a Fortune 10 multinational technology company, assisting with the drafting and negotiation of commercial technology and licensing agreements. Greg is on the CLE committee of the Georgia Bar Association's construction section, and I'm glad he is, because it's a huge help to us. And Greg received his law degree from the University of Georgia School of Law. We also have Michelle Thomas. Michelle joined the Atlanta Beltline in 2014 as Assistant General Counsel. In this role, she provides advice and counsel to the Beltline board members and staff on a broad range of legal issues, ranging from real estate and construction to risk management and intellectual property. Prior to her arrival at the Beltline, Ms. Thomas was a Senior Assistant County Attorney for the DeKalb County Law Department. Ms. Thomas holds bar memberships in Georgia and Pennsylvania. And last, we have Matt Wilson. Matt is a partner in the corporate and intellectual property practices and co-leader of the entertainment and sports industry team. He advises his clients on legal matters related to entertainment, technology, new media, and advertising. He's a trusted ally and strategic counselor on business and personal matters as they relate to the very visible career paths of his clients. I'd like to point out that Matt has a special interest and personal experience with playing music and the issues that musical artists face. Matt, I may not have forgotten the name of your firm there. If you would please help me.
It's okay, Arnold Golden Gregory.
There you go, AGG. I apologize for that. All right. Well, with that said, we're going to move directly into our discussion today on a number of issues that are at that intersection of construction and IP. And I'm hoping that we can have a good and lively discussion with our panel. And I'd ask that you feel free to participate by submitting your questions again in the Q&A function of Zoom. First, I think I'll start with an issue that's been around for a long time, and perhaps we can talk about how this is playing out both in the past and today. And that has to do with rights to photos or images of a building or a construction project. Very often you see, as a project goes up, many people want to use the images. They want to use them for their advertising. Oh, look, we were a part of this. Or they want to use them to show that they're able to do projects of a particular type or complexity. And you can have issues with who owns the right or who owns the ability to take a picture of a project and who owns the picture. So I'm gonna throw this out if I can. Liza, I think you're with a design firm and it's been a design builder. It's been my experience that designers often like to showcase projects in their marketing material. So would you talk to us a little bit about from your perspective how this issue comes up and how it should be handled?
From our perspective, most of the time it's really just a matter of working with our clients. We don't really address it from a who has what legal right issue. For us, regardless of who owns the designs, for us it's a matter of what our clients' privacy concerns are more than anything else. So that really tends to be what the driver for us. Obviously, we want to use promotional materials as much as possible, but we have systems in place to make sure that we're getting that permission from the owner, just because that's our primary concern, is to make sure that we've got a happy owner. So
as a design builder, do you typically subcontract the design work to a design firm, an architect or an engineer, or is that something you do in-house?
It depends on the project. So we have internal design teams and they do a fair bulk of our design if we're doing design build. But occasionally we've just got too much work to do, and we don't have the capacity to design everything. And so occasionally we will sub out some of that design work, but we keep growing and growing so we can just keep more of it in-house. So
do you find that the issues surrounding ownership of design and ownership of the images coming from design are ones that are sort of important and negotiated, or is that one that's more of a sort of boilerplate type thing?
So the images are not usually heavily hotly negotiated during the contracting phase, but the ownership of certainly the design documents is an important issue for us. And I think when Greg and I originally talked about this, I said, I'm glad this is on Zoom, so I won't have anyone throwing rotten vegetables at me. But, as a design builder, we believe that, we should be the ones who own the design because the risk sits with us. So, that is an important issue for us, is to hold on to that design and, license its use for the owner to be able to obviously use the building appropriately. But otherwise, we sort of treat it as, you've hired us to build you a building, not to produce a bunch of designs for you. So that's our standard take on the matter.
Peter, I would chime in. Something that I've been seeing quite a bit lately, especially with the proliferation of filming going on around Atlanta, is I typically am representing, in some cases, the production studios, in other cases, folks that are signing location agreements out to the production studios. And the question often comes up. Does the property owner have the right to sign a waiver in favor of the production studio for purposes of filming on that location site? And in a lot of cases, the owner of the building may not have that copyright, so they may not have the right to sign that waiver. So, what I typically advise folks when they're in the design stage, and I'm certainly not a construction attorney and will not pretend to be, but it's very important that if they don't obtain the copyright, the ownership in those copyrights to the architecture in the building that they own, then they should at least be securing very broad, comprehensive licenses that would then allow them to tell Marvel they can come in their restaurant, their bar, and film whatever scene they want to, because that's going to be great for them in the long run to have a movie going on in their building. And oftentimes that there is an issue there.
Matt, for those of us who are not copyright lawyers by trade, what rights does an owner need to be able to then allow Marvel to come in? Is it a derivative work at that point, or how is that looked at under the law?
The Copyright Act gives the owner of the copyright, the author, certain exclusive rights. And within those exclusive rights is what we often call a bundle of rights. It includes the right to display, the right to reproduce, the right to publicly perform, distribution, the right to make derivative works from the underlying work. So in the context of a film, typically we're talking about reproduction, display, and public performance. And oftentimes, if you buy a painting, for example, you have the right to display that painting, but not make a copy of it, not publicly perform it outside of the context of its initial display, et cetera, et cetera. So back to the building context, typically if you're not going to acquire the full bundle of exclusive rights that are associated with the copyright, you at least want to make sure that your license includes all of those various activities.
All right, Greg, I think you represent a lot of owners, so it might be interesting to hear your perspective on ownership of design rights and how much does an owner need, how much does an owner want?
Thank you, Peter. Yes, yeah. I mean, my practice revolves around representing owners and developers of construction projects. So, I mean, I think it goes back to what Lisa said. Lisa said in the beginning is that it really depends. It depends on what the owner wants out of that particular project. There's certainly going to be, if you're talking about a large LNG multi-billion-dollar facility, it's going to be a rare time when the owner actually gets ownership of, say, the technology process rights that go through and help the LNG be created or however it works. But if it on the other hand, if it's a multifamily or hospitality hotel, something along those lines, frequently owners want to be able to have a design and then be able to recreate it in another place if that's successful. So frequently then in those cases, the owners will want to push for, the design is ours, it's a work made for hire, all of the work product that comes during this project is ours. And that's something that we want to be able to use later if possible. Then you might get down to the other hand where it's just a warehouse or something relatively simple design wise, where again the owner might not care. They might say, okay, fine, we're just going to license it, we're going to have it. But we do definitely still need the rights to be able to use it, to be able to show it to if someone's going to come in and repair, if someone's going to maintain, they have to make sure that those rights are there forever so that they can make any changes if necessary.
Do you run into issues when, say, an owner builds a manufacturing facility and they need to expand it? They need to add something onto the building. And so they may need to change the way it looks from the outside, or they may need to use part of the existing design to overlay new design on it. Is that an issue you face?
Yeah, I mean, that can certainly be a situation where the owner doesn't have the right to doesn't have the license to do that from the original contract. And then you're going to run into issues there with expansion, with using the original design to do that. So that's something that we always try and push for if possible. It's not something that designers always will agree to. If they're going to, then typically there's some sort of, indemnification or waiver that says, if you use this design and we're not a part of it, then you're taking on all the risk for using it. This isn't something that can come back on us. So that's something that's typical in the market at the moment for those kinds of expansions. And that's, let's be perfectly honest, that's kind of a reasonable ask, in that if they're doing an expansion and they're not involving the original designer, unless they're finding a defect in the original design, in the original building, that's a separate issue. If they're doing something in expansion they're not a part of, then they typically ask for some sort of waiver for that.
We'll talk about some defect issues hopefully a little bit later. I've had a question come in, and this may be better for Matt and Michelle. Even if a person takes a photo or paints a painting of a building, I guess technically they're creating a derivative work of somebody's copyrighted design. Is that technically an infringement? And how does the fair use exception play into that?
Well, I won't go too deep into fair use. That could be hours and hours of its own webinar. But generally, the photographer owns a copyright in that photo. However, the subject matter of the photo may be owned by someone else, whether it's a copyright, it could also be a trademark. So you have these rights bumping up against one another. If the photographer has a fair use excuse for using the photograph of another copyrighted work, then that would allow them to use it. But again, fair use is an ever evolving concept. But standard stuff like newsworthiness and teaching, obviously, there are fair use exceptions for criticism and so forth. But generally, I cannot go take a photo of my client's mural that's on a wall because he has a copyright in that mural and use that photograph for a commercial purpose, for example. So it wholly depends on what the subject matter is, and the questioner is correct. If there is a copyright in that image that's being depicted, then I am precluded from using the photo for any non-fair use purposes. And I think that was a circular answer without answering.
Right. I mean, we had that issue come up with folks, being out for a public event like our Art on the Atlanta Beltline or our Lantern Parade. Folks are constantly taking photographs. We actually have our own photographers, so we get the copyright from them so that we can, own any type of images, and then, we'll have them take photos of our art as well. But I know that other people are doing that, and certainly they can't, use that for their commercial purposes. And we sometimes see that, you may be on sort of a weekend jaunt to a store and see, a reproduction of something. Oh my gosh, that's one of our artists. So it does happen, and but we strive to have that not happen. So.
And it's something that a lot of folks, I think, are simply unaware of. I have a client that's a pretty well-known muralist, I said a second ago, and he recently discovered that one of his murals is being portrayed on billboards around town by a real estate developer. And we sent a very nice letter to the developer and just mentioned that he was using the image without consent and monetary compensation. And he said, but it's a public painting. And that's the answer we get a lot when we raise these issues.
Well, Matt, that actually leads us into, I think, the next area I find interesting, and that is sort of the concept of moral rights and how much does an artist continue to own or control something? And Michelle, I think as you've mentioned, the Beltline has a lot of art that's part of it, and how do you handle the moral rights issues? And for those who aren't familiar, and I think this is something you see a lot of in civil law, it's really just beginning to become codified here in the U.S., where the artist may continue to have some rights in a building or a piece of art or a mural so that it can't necessarily be torn down or be relocated or be altered or changed in some way. Michelle, would you talk to us a little bit about how the Beltline deals with that?
Sure. I will say, we're still fairly a new project. We haven't had a whole lot of experience, but we do have tons of art, and we do have murals. And what we try to do, and because part of our purpose is to sort of foster and develop public art, we kind of want to have a straddling type of relationship. We want to support our artists and make sure that, their rights are protected, and we also want to further the Atlanta Art on the Atlanta Beltline program. So what we try to do is get out front really early in terms of the artists. As soon as they submit proposals for us, we try to look at them. And once we evaluate them, we try to work with them from the beginning of, this is what, we see, you're putting up a mural, sculpture, even a public performance. And so these are kind of the parameters, and this is what we'd like. This is how we would like to use it. And when we say, hey, we would like to reproduce it, obviously we want to give you credit and we want to maintain the integrity of your work. So that's kind of where we start. And our art department is really good with, fostering relationship with the artist, because you want to kind of be there as soon as you can. And so we just try to do things as early as we can. And what we strive to do is, again, support the work, maintain its integrity. There may be times where we do have to do some maintenance that does come up sometimes. In terms of moving the art, that's rare, but it does happen. And sometimes we have an issue where something may not, we get a sort of a sketch and a description of artwork, and then we find out, oh, that's not quite, what we envisioned. And so we have, we do make sure that we negotiate and say, hey, we need to be able to review each stage. So up until the point where it is installed or displayed, we do have certain rights. And then, when it's existing, again, that maintenance issue comes up. But in terms of sort of more of a long-term art, where you have a building that may be sold, or there's a mural on a building, again, that may be sold, or something else happens, I think we're kind of, trying to do that right now. We have one developer that wants to work with us and do that. And I think the biggest thing is certainly what happens when the building is sold. So we just, you want to get out in front of all that. That's what I'll say. Make sure you get a good relationship and you maintain it, and you do things as early, and you think about things like that as early as you can.
Michelle, do you ask the artist to transfer moral rights to the Beltline, or do you ask them to waive their rights so that you have this flexibility down the road?
What we do is our art isn't permanent. So at this point, that's not something that we generally do, but what we say is we would like, we want sort of a non-exclusive license to reproduce. That's about as far as we generally go, but that's only because it's not, none of the art is permanent. And I know folks may have other experiences with things that are supposed to be permanent.
Liza, have you run into situations where you had a building, I don't know, the Guggenheim or something, where it's artistically distinct, and yet there's some need by an owner to do something to it that would change the look and feel of that exterior, that facade?
Our buildings tend to be more, focused on function than form. So we allow in our license that our owner has the right to modify the building. We do a lot of warehouses, self-storage. We have no deep-seated moral rights for those, or even for our multifamily projects. They're pretty cookie cutter. So that's not really been an issue for us. And what we find is that it is important to our owners to be able to modify those buildings where they need to. So that's one thing that we tend to give on. So
have you had any owners who, and again, it may be a function of what type of work you're doing, but have you had any owners who have said, hey, we want to include art, we want to have an art gallery in the downstairs, or we're having the sculpture put in as part of the building, and then you've had to work with that designer? Or is that something where you typically see the owner hold that contract?
It's honestly, it's not something that I've seen, in-house with a design builder. I've dealt with it a little bit, back when I was in Greg's shoes representing owners. And yeah, you work with the designer to figure out, what's going to be mutually beneficial for the two of you. But here, we don't really run into that a lot. So.
I'm going to throw out a comment that's come in on the chat line. It says, assuming an artist's work qualifies for VARA protection, perhaps our IP folks can tell us what that is. I understand an artist can only waive but not assign their moral rights.
Right, that's right. So the moral rights are personal to the artist; they cannot be transferred. Unlike normal copyright protections, they last the lifetime of that specific artist, or if there's multiple artists, then it's the lifetime of the last artist that passes away that's responsible for the work. But they can be waived, and if we're talking about working from the perspective of a building owner, for example, that's going to have an art installation created, particularly attached to their building, they want to be certain that there is a full waiver of the artist's moral rights, and that waiver is pretty specific what the Visual Artists' Rights Act requires to waive those rights. It includes identification of the work, has to be signed by both parties, which not all waivers are required to include the party benefiting sign as well, but also that the intended use is identified in the waiver as well. So waivers can be conditional. They can also expire if there's a succession of interest, et cetera. So it's really important that waiver addresses all of those concepts from the perspective of the property owner.
If I can ask a couple of follow-ups. Did VARA create rights in things that pre-existed it? For instance, there's the whale mural that's here in Atlanta. I think that existed before VARA. Did the artist suddenly have a right that came into existence even though they had done that work prior? Or phrased as we would look at it, are there time bombs that we need to be aware of or in buildings that if we go to work on them, they're going to go off on us?
I've never had that issue come up. I would assume, because VARA is an amendment to the Copyright Act, that to the extent a work is identified in the Copyright Act, and it includes the types of works that are available for moral right protection. I know those include visual art, like paintings, sculptures, drawings, and prints and photos. I'm not sure if it extends beyond that universe of works, but frankly, I'd have to look into that and circle back with you folks, unless someone else here knows the answer.
Do the VARA rights, I think you said they're personal to the artist. Do they pass to the artist's estate when they die, or do they go away?
No. The rights that are protected by VARA, which include the right of attribution and integrity. Integrity is the work is not distorted, mutilated, destroyed, damaged. All of those rights expire at death, so they do not pass on.
And so we understand this isn't a theoretical. I believe there's a case in New York City right now, somewhere in the Northeast, where there was a mural on a building and the developers came in and basically took the building down, and the mural was destroyed, and the artist has filed lawsuits based on their moral rights to have that mural protected. We've got another comment in the chat line, which I'll tie back into what we've been discussing. A drawing of an old building, such as a building on an Ivy League campus. Do you have to find out if the college owns the copyright in a building from the 17 or 1800s? Or has that copyright expired and now you're free to create images, take pictures, etc.?
In most cases, I would assume that copyright's expired. We're talking about current post 77, in other words, January 1, 78 works are afforded the lifetime plus 70 years term. Prior to that, it was much shorter, 50 years, I believe, and there's some other bells and whistles attached. But I would assume anything dating back to the 19th century is well expired at this point.
Greg and Michelle, this may be a comment that you'd like to address. I know that if you go to France and look at the Eiffel Tower at night, it has a light show, and it's got all kinds of different things that happen on the light show. And obviously, people from around the world record that light show. But if you're posting that on the internet, you may get a letter saying that that light show is subject to, I believe, copyright in France.
Right.
Is that the same here in the U.S.? Can an owner do something on their building or their artwork and then protect that from other people using it, displaying it?
I mean, yeah, I mean, I think that they can, using, anything like that, that's unique, right? Because there's an argument that obviously that's their own creation, that you can't use it for commercial purposes. So, if you're using for your own personal use, that's one thing, but using it for commercial purposes is something else. And so then those rights, their copyrights would come into play.
Yeah, I would agree
Any
with that.
comments?
No, I would agree with that. I mean, I think that from most of the clients I represent point of view, they wouldn't necessarily have a big issue with someone, putting a picture of their warehouse on something, depending on how much their money they're making off of it, I suppose. But in certain circumstances where it is more unique, as Michelle says, that can certainly be something where the owner would have an issue and want to be compensated for that.
All right, I want to change gears for a minute and talk about an issue that is perhaps more construction than it is copyright, but it's one that we're finding to be not well defined in the law. For a number of years, we've had people do drafting of design documents. Those then morphed into CAD as we began using computer-aided technologies. Now we're working with 3D models, and we see collaborative efforts where you have a designer. The designer does parts of the model. Perhaps the contractors or subcontractors are adding to it. You may push fire protection onto a particular sub. You may push steel connections onto a particular steel supplier. And you may even do, within a building that's fully designed, a design build HVAC system where all of that has to be brought to the table by the mechanical contractor. And all that has to be put into the model, because contractually the model is what all the parties are using for design information and for trying to make it fit together. What happens when there's a mistake in this thing? Who, from a copyright standpoint, who's got the responsibility for that?
Well, I can dive into this one a little bit. I mean, it again is going to depend a little bit upon the project itself. If the owner is contracting with say a design build firm who has a complete wrap of the project, and you're just dealing with that one entity, then that's the advantage of dealing with one entity, the advantage of dealing with design build firms, right? Because you don't have to look around at the different places. It's the design builder, it's the defect would be under their responsibility. If you're dealing, however, with an architect on one hand and a general contractor on the other hand, and there's been subs of both or consultants in that way, then you're going to look a little bit at the contracts themselves. At some point the architect agreement will probably say that at some point their responsibility ends and they're only managing or they're only reviewing for certain issues, and then at that point their liability kind of ends and the liability of someone else changing at the general contractor, one of their subcontractors, begins. So yeah, it can definitely be a very complex contractual question. It's going to be a very factually based question. As to when things changed, as to when things came in, who was making the changes, and something that's always going to be a big issue to kind of unravel.
Yeah, we find it's really important to make sure that you have someone who's quarterbacking, the integration of the design. For a lot of our projects, if they're completely design build, it's obvious. As far as the owner is concerned, we're in charge. But it gets more complicated because we often find that our owners come to us and say, well, we have the civil that we like to use, or, this geotech. And, then we have conversations, well, who's in charge of making sure that all these things coordinate? And typically that's us. For, our plan and spec, then we talk to the owner and we say, we're going to do some design build work, but, you still need your architect to be quarterbacking this. You get into a lot of issues when you've got no one who's taken responsibility for that. And so that's probably one of the first things that we talk about with our owners if they don't want to do full design build, is just to make sure who's responsible for coordination. You know, otherwise you end up with these disasters where you've got things running into columns, and you know, someone's got to go back and redo it. So,
and then you have the issue, let's make it more complex. Let's say that there's been a termination and you're bringing in a new firm, a new architect, a new designer, whatever, whoever it may be. And then it gets, you know, it's you know, 10 times the issues, because you're trying to figure out what was, it's even more factually based. You're trying to figure out what was done when, by who had responsibility at that time. You know, did the new designer take over responsibility and verify the previous designs? Do you have a license to that? Or, you know, when was title to license passed? Do you even have title? Do you have the right licenses in the first place? And it can just become insanely complex down the line.
Yeah, that's where I was going to go next was, Liza, you mentioned having someone who quarterbacks this integration. Are they actually looking at licensing to make sure that when information gets introduced into a model or BIM system of some kind, that the license rights are appropriate for the use of that by other parties?
You know, I hadn't really thought of it from, you know, a licensing perspective before. You know, we more focus on, you know, the practical day-to-day of how we get to the end result. That's a good question that I'm going to have to go back and look at my contracts and think about, to be honest.
Well, I know the AIA has a rights in data document that they can get parties to sign. I'll be honest, I've not studied that at great length. It generally favors, obviously, the architect. It's the AIA, so the most of the rights rest with the architect. But if any of you have looked at one of those projects and done any sort of, you know, due diligence, mandatory flow down clauses, what types of provisions are you using to make sure that the rights are there at the end of the day when you need them in the hands of whoever's supposed to have them?
You know, I think we're really trying to make sure, interestingly, I suppose, thinking back into some of the contracts I've done lately, we're making sure more on when it's just one person, that it is that entity has the full responsibility for all of that scope, that they're really taking everything from all of the consultants and all the contractors and subcontractors and making sure that it's all together in one place, and that they're responsible for it. You know, I don't know that when we've done a lot of split scope contracts, which is certainly not atypical to have an architect and a general contractor, and most of the AIA forms are built around having that kind of split scope. You know, a lot of those AIA contracts will still say that the architect is responsible, but I'd have to go back and look through those, like the B104, I think that really says what the architect's rights are when its liability ends in terms of these you know, shop drawings or whatever it is that might be incorporated into the design. I believe they say, and if they don't, I believe we've tried to enter in that the architect will review anything that comes in from the contract from the general contractor and will incorporate as necessary, and then at that point it becomes the architect's responsibility. But if that's not there as boilerplate language, and it might not be in these AIA contracts, and that's something that people need to be aware of.
Well, Greg, let me push you a little bit on that. How does that work in the context of electronic models and electronic designs where, for instance, the subcontractor is directly inputting that information into the design?
Well, actually, I think it's even a little bit easier with a lot of these electronic, because for you're able to see at that point who is logging in from what login, who is making certain changes, exactly what time they were made, and all of that information should be kept and should be logged, and you should be able to go look at that. So actually almost a little bit easier now that it's electronic versus when something was just kept in a file cabinet, and you know, there might be a lot of drawings that pile up and everything kind of gets pushed together and no one's really sure who did it. Now with all of these electronic logs, it's a lot easier to see who was responsible for a certain change.
Michelle and Matt, I recently helped I'm finishing up helping with a residential contract. Now it's a multi-million-dollar house, so it's you know, not not a small one. But the rights in the design were something that we went back and forth with a lot. And ultimately, the owner's concern was, A, they need to be able to obviously maintain their house going forward, but they just wanted to make sure that no one got one exactly like theirs. They were fine with the architect owning the rights. He just couldn't reuse that design completely. Have you run into things like that where you're parceling up that bundle of rights, not necessarily transferring them, but maybe putting encumbrances on how people can use them? Like an artist, you do this for me, it is unique. You cannot now go and create the same thing for somebody else.
Right. Occasionally we've had that come up. I think we are in the process, of looking for some sort of unique pieces. And yeah, we certainly, we don't want anyone to have a derivative work. So we have had that issue come up in the past. And so, we're certainly on the lookout for it now. So that's something that we've certainly negotiated before. And then, if folks want to use sort of that design or something like it for their own sort of portfolio purposes, that's certainly something that folks, artists can negotiate for, and we're generally pretty amenable to that. But in terms of uniqueness, that is something that we we look out for and that we try to preserve, for the purposes of Art on the Beltline and really just any other portion of our arts program.
Yeah, and to piggyback on that, from the perspective of the artist, particularly if we're doing a art installation agreement or something, we always start with a very limited license that allows the owner of the building or the owner of the sculpture or whoever it might be to have the right to display it. They can obviously sell it for sale doctrine style. But beyond that, we limit the scope of rights to just that. They certainly cannot, slap it on a T-shirt and sell it or have it depicted in a movie without our consent. And then even beyond that, typically we request maintenance obligations on the part of the owner. If the artist's name is going to be attached to this sculpture or this mural, we want to ensure that it's taken care of and it doesn't come under disrepair. Weather, time, things happen. So the artist always wants to ensure that the artwork integrity is maintained, and that kind of bumps up against the rights that are recognized by the by VERA, and those moral rights we talked about earlier. So from an artist perspective, we typically try to address all that stuff clearly in the contract, so there's no questions going forward.
And even with our boring buildings, we run into this all the time where the owner just, they want to make sure that they're not having the same cookie cutter that someone else is having. We also see conversely owners, and sometimes it's in the same contract, that also want to make sure that they can use that overall look in their future buildings, even if they aren't using us. So, I think everyone's really thinking about making sure that they're, they have the right to be unique, but, also aren't tied to the same, if artists, my architects would be thrilled to hear that, for their future projects. So.
Just to go ahead.
Another issue I've seen come up recently is a landlord that leases his building, for a long time, be it a restaurant or what have you, then engaging an artist to come in and paint on the wall. And then all of a sudden, the owner of the building has an issue that never expected because the tenant has decided to hire, well-known artist X down the street to paint a big mural on the side of the building.
You've had Banksy come in, and now you got to deal with that. in that case, what happens? I mean, does the artist have some right that transcends the limitations of the lease?
Typically, the moral right would be recognized by VERA. I mean, you were talking about the New York case earlier, and that case has the perfect storm of a bunch of really crazy facts. And it was a $6.75 million verdict in favor of the artist. But again, I think the facts in that case were pretty egregious. But yes, the answer to your question is yes. The artist will have the right to preclude that mural from being destroyed to the extent it can't be removed without being destroyed. But there's some other factors involved, whether the art is of recognized stature and some other elements. But generally, the answer is yes.
And we've had that come up we have a facade improvement program. So you have the business owner, you have the landlord involved, you have the artist involved. So bringing all those folks to the table and kind of hammering out what happens with their unique design, or what they feel is important to preserve within that design. So we've had to work with all of those folks, in a way that everybody kind of, gets on the same page.
Do you find any similarities between these issues and sort of historic preservation issues, where you're maybe telling a building owner, you have to maintain the facade. You do what you want to inside, but you got to maintain that look on the outside.
Yeah, that's another thing you have to add in there when you kind of think of it. You gotta have to make all of those pieces fit together. We have not, I'm trying to think, we have not had that come up. We haven't done a whole lot of facade improvement projects. I think we're looking at maybe completing 7 or 8 this year.
Just as we're discussing, historic preservation sort of strikes me a lot as the public having almost a moral right in the look of this building, because it's been there for a certain amount of time, or it's unique to the community or something like that. So I don't know if copyright law factors into any of that or not, but it's a thought. Got a question that's kind of interesting on the chat line. What issues arise when a building is used in a film to represent another existing building, i.e. when the Cobb Energy Performing Arts Center was used as the CDC building in the Walking Dead series? I know my office is in Midtown, and it seems like Marvel's down here filming all the time. And I can go watch a Marvel movie with my kids, and sure enough, there's some building I recognize.
Yep. Well, I tell you, Marvel and most of the big film studios will obtain clearances for everything that can be seen in the shot, unless it's completely obscured and blurred and unrecognizable. They'll get clearances just to avoid the headaches later. But the question is interesting and always comes up. How many location agreements are required when you're filming on Decatur Square or Marietta Square? Does every building owner need to sign something? And the studios will typically go out and get all those clearances. The legal answer is wholly dependent on an analysis of fair use and such.
And we've had that folks always want to film on the Beltline. And so we've had folks come to us many times and say, well, can you just give us a waiver for this artwork? And I always say, I think you better contact the artist. But yeah, it happens quite a bit. And we have filming that takes place and on another couple of properties that we own, and we have those issues. And we always, if you come to us for the waiver for the artist, we always say, you want to reach out to the artist.
All right, let me layer a little more complexity on top of that. We're beginning to see in construction an expanded use of drones, because drones allow you to look at buildings from different ways, look at job sites, understand what you have out there, and maybe track progress. Are there any issues associated with using drones? For instance, if you're flying over a site, the Beltline, you're trying to come in to do some pathway design or something like that, and suddenly you're capturing images of art. Maybe that needs to be put into the plan so people know, well, you can't dig here, we've got to restrict your access there. Are these issues that y'all are seeing any? And this is for the whole panel, really.
For ABI, for the Beltline, it hasn't come up a lot, but it's coming up more and more. Others maybe can speak to this, and it's happening, maybe more in your various industries. But for us, it's not a lot, but I know it's increasing.
I think for the site plans, when the owner and contractor are really talking about where exactly, this is going to be your laydown area, this is an area you do not have permission to access. On the site plans, it's rarely going to be a Google Earth equivalent with real specifics like that. I mean, there'll be street names, and there may be lines of easements and all those types of things, but typically I see just a highlighted box. You can go here, you can't go here. In this highlighted area, you can go. I think that's purposeful. They're trying to do that to avoid any use of anyone else's buildings or art or unique property, however it may be, in terms of figuring out everything that needs to be done. I mean, you could also argue that they wouldn't be using that art for a commercial purpose if it was on a site plan or along those lines, but I think we just try to avoid any headaches down the line, I think is a good term, and just make it as detailed as it needs to be and no more.
Yeah, I mean, we use drones on a fairly regular basis for, marketing purposes, but, again, we're, as Greg said, we're trying to keep it a pretty close shot. You want just the building. You don't really want to be highlighting the building next door. So that really hasn't been an issue. And then I would say, for the other uses where we're, especially doing inspections, that kind of thing, it's hard to say that any sort of incidental, glimpses you're seeing of other buildings would be somehow, a commercial use of that, that form. So.
Yeah, and a lot of it will again come back to the fair use analysis. I mean, is a shot that's going to be included in a television program depicting a mural because that mural is well known and represents what people think of Atlanta? Going to the Krog Street Tunnel and filming that tunnel, those kinds of uses are specifically targeted and used for a purpose. And I think the artist has a pretty good argument that those kinds of shots are being used for a commercial purpose, and they're not de minimis, they're not incidental. There's something beyond that.
Is there a difference? I'm just hearing you talk about Google Earth and stuff. Is there a difference between an image shot from a drone and an image shot from a satellite as to copyright? I mean, it's both an overhead shot.
Depends on how zoomed in it is, I suppose.
Okay.
If you can decipher what it is, and I'm representing the artist, I think we think that you flew over our art and zoomed in for a very specific purpose.
Well, all these point out that the issues that we face are continuing to multiply and they're continuing to evolve. We're not in a static technology environment, and so we're seeing more and more of sort of new technology driving development of the law as we have these new issues. We were talking a minute ago about what happens if Marvel films inside a building, but what happens if Marvel does some digital editing of what the building looks like inside, and somebody says, hey, I like that. I think I want to do that to the building. Marvel's publicly displayed this in a film or whatever. Do they have some kind of copyright in that now keeps the building owner from replicating that, or somebody else from in some way replicating that? I mean, it's a movie set for Christ's sake. It's not really a design itself. It's completely fictitious.
Yeah, I don't know that we've had that. I mean, I would say, of course, Marvel would want to be compensated.
I'm sure they would.
That's my first thought. But we have not experienced that. So that's a good question.
Yeah, I guess I would say off the cuff that to the extent it is an expression, then Marvel has a copyright in that design, unless the design is a derivative of the actual inside of the existing building, in which case that derivative work would be an infringement. So I guess it depends on the specifics.
I tell people that Orlando is the place you can go and find anything. If Disney hasn't done it or Universal hasn't done it, I mean, good heavens, there's a building that's an upside down house in Orlando. It's a commercial building. So what people see, they can design and they can build it. I mean, they can make it happen. It's just amazing how creative and how alive the construction and design industry is and what it can accomplish that people want. Well, we have about 5 minutes left. I'm going to, let's see if we have any other questions in here. I see a note, copyright protection was not extended to architecture until 1990, the same year that VARA went into effect. So at least for 20 plus years, 30 plus years, we've been dealing with copyright of architecture. Is there a point where that copyright protection expires, and suddenly a building becomes, sort of public use and anybody's free to use it, modify it, replicate it, etc.? I had a case years ago on the Healy building here in Atlanta, and fortunately they had some of the original plans on that building, and I mean the structure, the way it was put together was absolutely gorgeous. And I don't know that anyone could duplicate that today, but there's certainly parts of the look and feel of that building that if you wanted to sort of do a period building, you would want to incorporate that type of stuff. All right, well, I think we're close to the end of our time. I'll sort of go through and ask each of you if you have anything else you'd like to say. Let's start with you, Greg, because you're in the upper right corner of my screen, or left. I don't know about everybody else's. So.
No, thank you all for having me on. I think that from a construction point of view, it's always important to negotiate these provisions and to know I think Michelle was talking about knowing early on what you want. The earlier that the owner can know, or the developer can know what they want out of the project, whether they want a license, whether they want to own this, whether they want it to be exclusive, like we've talked about, the earlier you know these types of things, the easier it is to negotiate for all parties. It can be included in pricing, and you can talk about different options along those lines. But there's always that one issue that comes up a little later in negotiation, and everyone's head kind of explodes a little bit and says, no, this is what we always thought. So preparation is always the way to go with these. Know what you want, and make sure that you're getting all of the rights, whichever way you're going to go. Make sure you get all of the rights to which you're entitled, and then at that point you go on and you make a wonderful project together.
Michelle, any closing thoughts?
Oh, well, thank you so much for the opportunity to be on this panel. And, certainly I want to echo Greg and just say that, part of this is kind of developing a relationship, between, your artist, your consultant, your builder, everybody, and kind of, hashing everything out as well as you can. So that's all. Thank you so much.
Matt, any final comments?
Oh, yeah. Well, as Michelle said, thanks for having me. I appreciate it on the Georgia Bar and the copyright and construction section. Yeah, if you're purchasing a building that has some art on it, find out all you can. Is the artist still alive? Was there a contract for the installation? All of those kinds of things, because you don't want to have any surprises down the road when you decide you want to tear down a wall and expand, for example. And as always, pay your artists. Don't steal art.
Liza, any final comments?
Again, just to echo everyone else, thank you so much for having me. Getting to talk about these things has been a lot of fun. And yeah, to echo Greg, just make sure that you are thinking through what you want. Talk through each of these issues. That's where lawsuits happen, is where you just don't think through things enough, and there's some ambiguity, which I keep saying is the petri dish of disputes. So.
All right, well, I would like to thank all of you for joining us today. If you have additional questions, I'm sure you can reach out to the panel, or reach out to me, or you can contact Lane at State Bar, and he can send it to us. We haven't answered a lot of questions today. I hope we've raised some, and we've caused people to think about things. And we look forward to future opportunities to do these types of panels. I again thank the IP section for agreeing to do a joint presentation with us. I think it was actually y'all's idea. So we're very grateful, and I hope this has been beneficial for our members as well as for y'all's. Lane, I think we have about a minute left, so I'm going to turn it over to you for any final comments or instructions.
Ladies and gentlemen, this is just a reminder that the State Bar of Georgia will take care of all CLE reporting. Thank you for joining today, and have a great afternoon.
Thank you, everybody.